But that's my money. It's my money. You have to go. No. Once you put it into that irrevocable trust, it's out. Hi, Jeff Marsacci, the Plain English Attorney, and welcome to the video. Today, we are going to talk about amending an irrevocable trust. Wait a minute, you're not supposed to be able to do that. Well, okay, yeah, you're not. But here's how you can get the same exact outcome as if you were amending an irrevocable trust. Now, this is not something that's simple. It's not easy. I have clients that have revocable living trusts. They just want to update their estate plan. It's just simply printing out the document again as an amended and restated trust with the changes inside, sign it, witness, notarize, done. No problem. You can't really do that with an irrevocable trust. Now, here's the big understandings that you need to know if you're going to be setting up an irrevocable trust. And the first big thing is there has to be a solid reason for it. You're trying to get assets out of your control. If you think it's important for educational videos like this to get out there, then please help us out by subscribing to the channel. The two big cases and the two reasons we're going to talk about today is mainly Medicaid planning. Okay, you want these assets off your books in terms of Medicaid if you need Medicaid to pay for nursing home care down the road. Second thing, we're just going to use the example of getting something out of your taxable estate, and where we end up seeing a lot of use is irrevocable life insurance trusts. So this is an irrevocable trust that can hold a life insurance policy. It's in the hands of a trustee. The trustee pays the premiums. When you pass on, the life insurance pays into the trust. All of that life insurance money is not part of your balance sheet for estate taxes. So those are the two big ones. So you're taking whatever it is, you're putting it into this irrevocable trust. It's set up, your big elements here. You have a list of trustees, and our usual recommendation is still one trustee at a time, none of this co-trustee or whatnot, and go several layers deep. And then the second thing is you've got your beneficiaries listed. So after you're gone, here's where the assets go. Now, I want you to stick around until the end where we walk through how we had to do this process of, quote, amending an irrevocable trust 4 times. So there were 5 different versions of all of this. It was a mess, but you know what? There were some pretty solid reasons for making this happen. All right, so what exactly has to happen? First, in your irrevocable trust that's set up the first time, the trustee has to have the authority to take the assets out of the trust without necessarily distributing them to the beneficiaries at the end of the line. Now, usually this means that the trustee has the authority to recharacterize assets, making it go into some other type of format, convert it, or when we're talking about Medicaid planning, the way we craft them, it's not the way all attorneys craft them. We have the trustee is actually the beneficiary in the first phase, which is while the people are still alive. So this is why it's usually a trusted child who's helping them. That child is the one who's the trustee. They're the beneficiary. They can take the money out, put it into their own account, and spend the money on mom and dad. Take care of bills, whatnot, so that the whole pot of money there is not on the books for Medicaid planning for mom and dad. So, in that case, they can just take the money out, put it into a new irrevocable trust. But let's keep walking through the concepts. We've got some slides that are coming up that'll illustrate this a little better. You always want to keep this out of the hands of the grantor. So in other words, the trustee isn't just going to take it and give it back, because if you do that, you end up with all of the bad things, all the vulnerabilities that we were trying to get rid of in the first place by having an irrevocable trust. Those are out the door. If it's for Medicaid planning, you're restarting the 5-year clock, or Lord forbid you're already on Medicaid. It just becomes a mess. In the case of an ILIT, okay, you get those assets back into the hands of the person who set it up initially, and then they're putting it into a new trust. There's a 3-year quote look back period. So if you die within those 3 years, everything's still going to be included as part of their estate. All right. So we don't want that to happen in either case, unless there's absolutely no way to avoid it. And we don't set up trusts so that ends up having to be an issue. All right. Now, here's another big thing. When you're talking about things like ILETs or other irrevocable trusts, you're talking about a person gifting assets out of their estate for estate tax purposes, not for Medicaid planning, estate tax purposes. The money goes into the trust. Part of the rules to completely take it off the giver's balance sheet is the beneficiaries have to have a quote meaningful opportunity to take that money. So this is usually where, okay, if it's going to say all 5 of the kids, and I'll give you an example here where this happened. All 5 of the kids, well, all 5 of the kids each year are signing off, we don't want to take this money. Well, why would they do that? Why wouldn't they take the money? Because that money is being put into a life insurance policy that's going to pay off an awful lot more money down the road. And so it's in their own future best interest. They're going to sign the paperwork and say, we're not taking the money. So if you have a beneficiary that's being cut out for whatever reason, well, that's when we get to running through the slides. We're going to use that as a specific example, and we're going to list out example beneficiary names. But the big thing is, if that money's gone in, they now have a vested interest. So if you've got those 5 beneficiaries and one of them's being cut out, well, 1/5 of the value in that policy needs to come back out to them. So there has to be some way when the trustee's taking the policy and moving it into the new trust with only the 4 beneficiaries, that 5th beneficiary has to get paid their current value share. Otherwise, it's really wasn't a completed gift, and you're going to end up with some potential tax issues and confrontations down the road. They need to get their quote share out. So that's something that has to happen. Again, when we get through walking through the slides, I'm going to use that as an example, and I'll tell a story that really happened with a client. All right, so if we're setting up the irrevocable trust, I got to tell you, look, it's expensive because it has to be done right. It has to be drafted by an attorney who knows what they're doing. If you're trying to do this as a do-it-yourself, there's a big chance of failure. You really just don't want to try to mess with this stuff on your own. And the big thing is, you can't just change your mind later. I was working with several advisors at well, I'm not going to name the firm. It was a larger firm. I was coming in and actually teaching estate planning concepts to some of their younger and newer advisors. And then we were working on a case with an ILET. And I was as very clear as I could be. Hey, look, once you put this in there, that's it. It's done. It's in the hands of the trustee. It's no longer yours. 2 years later, he wants to take money and borrow against the policy. And I'm like, you can't. And he's like, but that's my money. It's my money. You have to go. No. Once you put it into that irrevocable trust, it's out. You can't have the benefit of it being out of your estate and at the same time say, it's my money. You can't do it. So that's something that you need to realize when you're setting this up from the start. You're putting something in and you're walking away from it. And that's whether it's an ILET or we're talking about Medicaid planning. All right, so let's start to walk through the slides in the example that I put together. All right, so let's just say we have this irrevocable trust. It's set up. We have life insurance with the cash value. We're going to use this as an ILET example just because it's going to illustrate that point about the beneficiary getting out whatever they had already in there as a vested interest. So there's a life insurance with the cash value, and they've got a checking account. Now, the idea for an ILET is, and we've got other materials on that, each year, the grantors, meaning usually the parents, they're putting money into the trust. The trustee has paperwork saying, hey, here's some money, you're allowed to take it. And they sign off and say, Nope, keep it there and invest it for us. Okay, that's when it goes in to pay the premiums for the life insurance. And the next year it repeats and it repeats and it repeats. Well, okay, so we have this, but now suddenly there's something going on with the family. So we've got the trustees are Stephen, Sarah, Stephanie, and Samuel. I'm intentionally make it not any of the beneficiaries. So again, it's Samuel, Stephen is first, Sarah is second, Stephanie is third, and Samuel is fourth. Now, in terms of beneficiaries, well, it's four kids. We've got Joe, Jennifer, Jake, and Jane. And then the family drama hits, and Jane goes off the deep end. And oh, Jane needs to be cut out as a beneficiary. Well, wait a minute. How are we going to do that exactly? All right. Well, we've crafted this irrevocable trust in such a way that the trustee has the ability to make these chess moves. First thing, we have an irrevocable trust, Roman numeral 2. What's going to end up with the life insurance with the cash value is in there, a checking account, and the same trustees. First Stephen, then Sarah, then Stephanie, then Samuel. If for some reason Samuel just didn't want to do it, we needed to add another contingent trustee or whatever. Okay, this is an opportunity to do that. But now the beneficiaries, it's only going to be Joe, Jennifer, and Jake. Jane is coming out. All right, so what do we do? First thing, we're going to have the document set up. It's going to list the new beneficiaries. It's going to list the trustees. And then, all right, we're going to take the life insurance and the cash value and move it into the irrevocable trust too. As this is happening, we have to have a valuation of exactly what that policy is worth. And typically it's the cash value. All right, so either we have to have 1/4 of the cash value come out, or there's some other transfer of funds. I've seen the parents just give the money to the trustee to give to that child that's being cut out. Or it can come out of the policy. There can be a readjustment of the policy, a reduction in the benefit, and then it can get made up later in subsequent premiums going into the new trust and into the new policy. But look, if it's $400,000 of cash value in that life insurance policy that's gonna pay out millions, well, okay, that $100,000 has to go to Jane. It has to come out. So Jane gets that money, and then we just move forward in the irrevocable trust Roman numeral 2. Well, that just keeps going. And now Jane isn't getting anything else. Now, in the case that I worked on, I didn't initially set this up, but I helped with it afterwards as this new trust was set up. There were 5 children. This was a blended family. And this was a second relationship much later in life for both mom and dad. And so they had the trustees. It was set up with someone outside the family as the initial trustee. I believe it was the accountant. And so the accountant was like, okay, we need to cut one of the kids off. She just got into bad relationships. I suspect, but can't say for sure. There were drugs involved and things like that. And it's just, no, look, this just became a big thing. She's got to get cut out. All right. So they did that examination, looked at the cash value, gave it out, had a release. Hey, you're getting this money. This is your interest in the trust, and you understand that's the end of it. But you're getting this money right now. Well, she took it and she signed, and that was it. Done. Then the policy moved over to the new trust. They could have redone a new life insurance policy and just moved the money, but at that point, they had gotten older and it would have been much higher premiums for the same benefit. And they just decided, no, we're going to reduce the policy and then we're going to fund it with more to build it back up. And they were able to do that with the insurance company. But they cut that 5th child out. Now, I can tell you, I think they made the right call because every couple of years I get a call from my office. Hey, I think they might have passed on, and I think I'm entitled to some money. I need to see the documents. And we basically tell them go pound sand. That's the end of it. You're done and you're out. All right, so let's talk about the case where this was Medicaid planning. It was done many years ago. It was done correctly. And the parents, mom and dad, they had two children, a son and a daughter. The daughter had two children, two sons. All right, so they wanted to protect everything in case Medicaid was needed. So we set up the irrevocable trust, put real estate in there. The son was the first trustee, the daughter was the second trustee, the daughter in law, son's wife, is the third trustee. And the beneficiaries are 50-50, son and daughter. So after both mom and dad are gone, it gets split equally. Daughter passes on. Okay, so now, well, okay, wait, we've still got the son there, and then the daughter in law is the second in line. I'd feel more comfortable if there were a third person as a trustee. We did have a trust company as a backup, but okay, fine. But the problem was both of the daughter's sons were adults, and apparently they were living in one of the houses that was inside the irrevocable trust, and they were kind of using it for selling drugs and all this other stuff. And it's like, oh, we got to stop this. And so what they needed to do was cut out those grandkids as the beneficiaries. And while we were working on it, let's go ahead and add another trustee. And so, all right, we set up a Roman numeral 2. Trustee had to move the property trust to trust, move the financial assets trust to trust, and that was it. So it was tedious because there were multiple investments in addition to a couple of properties. We had to deed the properties trust to trust. And yeah, we were able to cut those grandkids out. Well, wait. Didn't they have to get their beneficial share? No. Because there was no beneficial interest for these grandkids at that time. They weren't going to get anything until both, for the kid, their grandparents passed on and both of them were still alive. All right. What happened next? Son and daughter in law start squabbling. It looks like it's heading for divorce. We need to get her out as a trustee. We need to make sure that she can't access this money in case things go south. Okay, we ended up finding, I think it was a cousin and a niece or a nephew to be backup trustees, and we made trust Roman numeral 3. So it's now the son is the only beneficiary. He's the current trustee, and once mom and dad are gone, it's all his. But we had these other trustees in line so that it could end up going to the contingent family members down the road. I don't want to get too deep into it and give out any more details than that. All right. So, all right. Roman numeral 3, done. Son and daughter in law get back together. Everything's great. Everything's fine. We need to get her back in. Okay. Roman numeral 4, move everything again. At this point, they've kind of combined a bunch of financial assets. So it was the same process of setting up the new trust, moving, getting the deeds, and moving the stuff over for the property. But it was a little less work on the trustee because they had consolidated some of the financial accounts, but it still got moved. And then, guess what happens? Oh, yeah, it's definitely headed for divorce now for the son and the daughter in law. All right, we need to take her out again. We need to put backup people again. Move the assets again. This wasn't over just a couple of years. This was probably over about a 10-year period, and well, probably a little more than that. Maybe about a 15-year period. It was only about 3 or 4 years in that the daughter passed on, and we started having problems with the grandkids. But look, we were able to do this. This isn't amending. I guess the term that I've heard used in the legal circles is decanting a trust. Basically, it's moving the assets trust to trust. There are ways to do it. It's not amending an irrevocable trust. It does have complications, and it can get to be expensive because you got to set all this stuff up and move the assets, and it's a pain for the current trustee. But look, if it's important enough that it needs to be done, it can be done. It's not simple. So I hope you found that information useful. As I always tell my clients, please stay safe, plan ahead, and enjoy life. And whatever you do, make it a great day.